Welcome to this Evershed Sutherland podcast, where we will look at what lies ahead in the real estate dispute resolution world. My name's Bevan Jones. I'm a professional support lawyer within the real estate dispute resolution team at Evershed Sutherland, and I'm joined by Carly Fishwick, a senior associate in the Manchester team. We have joined up today to discuss some of the real estate and real estate disputes related developments which are on the horizon. There's plenty going on in this field at present, but we've decided to focus on just 10 or so developments, and you'll see that they focus heavily on reform. Reform in the law relating to property, both residential and commercial, reform in the landlord and tenant relationship, and reform as to how building safety is managed. So let's kick off with the Leasehold and Freehold Reform Act 2024. Carly, over to you.
Thanks, Anna. So taking a look first at the Leasehold and Freehold Reform Act 2024, which was passed in May 2024. This act intends to give better rights to the millions of people who have long residential leases in England and Wales. The most notable provisions of the act are as follows. New leasehold houses, but not flats, will be banned, save for in exceptional circumstances. Every purchaser of a new house in England and Wales will therefore own the freehold of their home and will not have to pay any ground rent. And secondly, the creation of longer, more accessible leases. Standard lease extensions will rise from 90 years for flats and 50 years for houses to 990 years each. Regulations passed since the introduction of the Act have seen the removal of the requirement for a new leaseholder to have owned their house or flat for 2 years before they can extend their lease or buy the freehold. Further regulations have also seen the extension of rights to manage and enfranchisement. Leaseholders in mixed residential and commercial buildings previously could not buy their freehold or take over the management of their building, where more than 25% of the floor space was non-residential, but they will now be able to do so if less than 50% of the floor space is non-residential. It was hoped that the Act would address current issues faced by current leaseholders and would restrict, cap, or phase out ground rents, but disappointingly, this did not happen, and the Act has therefore faced criticism as a result. So keeping on the theme of leasehold interests and moving on to look at leasehold and common hold reform. The government has recently introduced a common hold white paper, which promises to ban new leasehold flats by 2029 and make common hold the default tenure. This forms part of the government's commitment to providing leaseholders with greater rights, powers, and protections over their homes. And for those who are not familiar with the term common hold, this is a form of freehold ownership where each individual owns their unit outright, with no expiring term, unlike leasehold tenure. With common hold, the Common Hold Association decides how to manage the property, and it is anticipated that the owners of large residential blocks of flats will appoint a managing agent to deal with the day-to-day management of the building. Now, common hold ownership is common for flats in many other countries around the world, including Europe, America, Canada, Australia, and New Zealand. The paper is on the common hold system in the context of residential blocks of flats, but it does refer to its potential wider use in other settings, such as commercial blocks or retail and industrial parks and shopping centres. The government has promised to consult later this year on the best approach to banning new leasehold flats so that it can work effectively alongside a robust ban on leasehold houses, and will seek input from the industry and consumers on other fundamental points, such as potential exemptions for legitimate use and how to minimise disruption to housing supply. And the aim is to work jointly with the Welsh Government to ensure that the reforms apply across England and Wales.
Thanks, Carly. We're keeping on the residential theme, and I've got to mention the Renters' Rights Bill. This bill promises to offer greater security and stability to renters and improve the standard of housing stock in England, and different regimes apply in Wales and Scotland. So what are some of the key features of the bill? Well, as things currently stand, first, I think most people will have heard that the bill promises to bring an end to Section 21 no-fault evictions, and that's for new and existing tenancies. And it's also looking to reform landlords' grounds for possession, new grounds being introduced and existing grounds being varied, in particular when it comes to notice periods that landlord needs to give tenant. The idea being that more notice requirements will offer more security to tenants. Fixed terms assured tenancies and assured short-hold tenancies are to be abolished and replaced or converted to periodic tenancies, meaning that tenants will be able to stay in their homes until they decide to end the tenancy by giving 2 months' notice, or, of course, the landlord is able to make out one of the termination grounds. What might not be on everyone's radar is that the bill looks to end rental bidding. So landlords and agents will be prohibited from seeking for, or asking for accepting offers above the advertised rent. The bill also looks to limit how much rent a landlord can ask for in advance, and also proposes to limit and introduce a new procedure where it comes to in-tenancy rental increases. There will also be clearer expectations where it comes to addressing serious hazards within homes, and the private rented sector is to be subject to the decent home standards. Landlords also need to be registered on a new private rented sector database. There's plenty more I could mention, but I will end with the establishing of a private rented sector ombudsman. That's a government-approved redress scheme, which will aim to resolve disputes between tenants and landlords, and it will be compulsory for landlords in England to join the scheme, the cost for which hasn't yet been announced. It's anticipated that this bill will become law by October 2025, so this year. It could be earlier. It should also be noted that whilst the bill appears to have support within the Houses, it is currently with the House of Lords, and the Lords have proposed a number of quite significant amendments to the bill. So there's a big watch this space label attached to this development. Some of the amendments proposed by the Lords appear to address some of the concerns in the wider property industry, including with the lack of a transitional stage to allow those involved in the industry to adapt to the new regime, and also so that the court to look at the court's ability to cope with the anticipated increase in cases. So on to reform in the commercial landlord and tenant domain, Carly.
Thanks, Anna. So, the potential reform of the Landlord and Tenant Act 1954 has been a topic of conversation for many years. And as many of you listeners will know, the Act was introduced in order to provide security of tenure to business tenants during a shortage of commercial property stock following the Second World War. Over 70 years later, the Law Commission has now decided that the time is right to reflect on the current system and whether this meets the needs of the current commercial leasehold property market in England and Wales. So late last year, the Law Commission recently published a consultation paper which examined Part 2 of the Act. Part 2 of the Act provides security of tenure to business tenants. The examination was wide in scope and asked key questions about possible options to reform Part 2 of the Act. It also considered all elements of the current framework for lease renewal, from the arguably arduous process to contract a lease out of the security of tenure provisions of the Act, to the substance of the grounds to oppose the renewal of a tenancy, the terms of the new leases, and the issue of interim rent. The first consultation stage closed recently in mid-February, and we're now waiting for the Commission to publish a second technical consultation paper, which is based on the responses received to the first stage consultation and the conclusions reached. And we will now continue to follow the consultation and update you as appropriate within our future editions of InFocus, so do watch this space.
Thanks, Carly. And we're moving now onto the high streets of England, and regulations which were laid before Parliament in late 2024 and which came into force early December of that same year. These are the Local Authorities, Rental Auctions England, and Town and Country Planning General Permitted Development Amendments Regulations 2024. These enact measures found in Part 10 of the Levelling Up and Regeneration Act 2023. These regulations allow local authorities to facilitate the letting of property on the high street in England that have been vacant for a year or for large periods of time within a 2-year period. The aim being to revitalise high streets. In January, the government launched the High Street Rental Auctions Fund, and that's a 1.5 million pot aimed at supporting local authorities to use their new powers. They're allowing them to fund the cost of producing a register of vacant commercial high street properties and to refurbish vacant properties subject to rental auction. One thing for landlords to look out for with the scheme is the strict deadlines that apply once the process has been triggered. We know that 11 councils are effectively trialling the scheme. They've having signed up as early adopters, and it'll be interesting to see to what extent they and other local authorities apply these new powers. So we're going to jump to Scotland now. Carly, what has been happening in terms of reform in Scotland when it comes to commercial leases?
The Leases Automatic Continuation etc. Scotland Bill has been recently introduced to Scottish Parliament on the 11th of December 2024 and proposes significant reform to Scottish lease law. This proposed reform will be interesting to landlords, tenants and property investors in Scotland. At present, Scottish commercial leases do not necessarily end on their expiry date. The landlord or the tenant must give notice to quit at least 40 days before the termination date, otherwise the lease will continue. This can catch both sides unawares and lead to confusion and dispute about whether sufficient notice is being given. The bill proposes to address this and provide greater flexibility to parties to agree that their commercial lease will end on the expiry date and not automatically continue, thereby simplifying the position for both landlords and tenants. Responses to a consultation on the terms of the bill were due by the 7th of March, and we now await a report on the bill before it is further debated. We're keeping an eye out for the report and we'll release a briefing once this has been released. So for those interested in following the bill, please do keep an eye out for this.
The Building Safety Act 2022. Most will be familiar with this act, and we are in fact coming up to 3 years since this significant piece of legislation was passed. Most of its provisions are now in force, or at least they are in England, but there are a few remaining provisions still yet to take effect, and so we're waiting regulations in relation to those. For example, Section 113 of the Act is not yet in force. This provision requires landlords to provide certain building safety information to their tenants, including in their rent demands. Recent amendments were made to the Building Safety Act, introduced by the Leasehold and Freehold Reform 2024, and the government has also consulted on matters such as the qualifying criteria for obtaining leasehold protections in the Building Safety Act, where a leasehold property is owned by 2 or more individuals. A levy is to be imposed on developers of new residential buildings to fund the remediation of unsafe buildings. That's the Building Safety Levy, and that was due to come to effect later this year, but that date has been moved to autumn 2026. In Scotland, the government has introduced the Housing Cladding Remediation Scotland Act 2024, and we are awaiting in Wales from the Welsh Government a promised Building Safety Wales Bill, and that should be introduced later this year. We're also following how the First Tier Tribunal and Upper Tribunal interpret their own powers or new powers under the Building Safety Act and are awaiting a few appeal decisions. In particular, the Court of Appeal recently heard 2 decisions involving the extent of leaseholder protections under the Building Safety Act and also the Tribunal's powers to grant remediation contribution orders. And keeping on the safety-related theme, the Terrorism Protection of Premises Act 2025. This is a fairly hot off the press development as this act was passed only a few weeks ago on the 3rd of April 2025. The act aims to improve public safety by imposing a legal duty on those responsible for qualifying premises and events to implement measures that reduce the risk of harm during terrorist attacks. The act is also known as Martin's Law in tribute of Martin Hett, who was killed alongside 21 others in the 2017 Manchester Arena attack. What it means to be a qualifying premises or event largely comes down to the activity being held at the premises, whether the premises is open fully or partly to the public, and the number of individuals, including staff, who can reasonably be expected to be present at the same time in connection with one or more of the uses specified in the Act. And that includes, for example, shops, hotels, bars, nightclubs, etc.
Thanks, Anna. So we're ending with a watch this space in relation to the energy performance of buildings. And that is because of two consultations which were launched recently, which both consider the energy performance of buildings. The Energy Performance of Buildings Framework and Energy Performance of Private Rented Homes. These two recently launched consultations seek views upon, firstly, the reform of energy performance of buildings, EPB framework, and secondly, on the government's proposals to raise minimum energy efficiency standards, otherwise known as MEES, for privately rented homes in England and Wales by 2030. The deadline to respond to the first consultation has now passed, but the deadline for responses to the second consultation remains open until the 2nd of May. It'll be interesting to see what steps the government will take after it has considered the responses to the consultations. And as always, we will keep you updated in our future editions of InFocus. Passing back now to Anna to conclude.
Thanks, Carly. That brings us to the end of this podcast. We hope that you found it interesting. The real estate dispute resolution team have written briefings on most of the developments highlighted in this session, if you'd like to dive a little deeper into any of these. Or if you'd like to discuss any of the developments mentioned, please do get in touch with a member of the real estate dispute resolutions team here at Evershed Sutherland. Thank you for listening.